Okay, let's talk first about what it means for the issue to be the same. The important point here is that the same word or phrase can shift in meaning depending on the legal context. So, when a word is used in context number 1, and that context is materially different from context number 2, the word's meaning may not be the same. Thus, lawyers cannot assume that a finding made in context number 1 is necessarily transferable into context number 2. For example, imagine that you are a residential law student who has moved to New Hampshire to go to UNH Law. A number of questions can arise. Are you a resident of the state of New Hampshire for purposes of in-state tuition? How about for purposes of diversity jurisdiction? Recall that we talked a little bit about diversity jurisdiction in Chapter 1, and we'll return to the topic near the end of the course. What about for purposes of registering to vote in our state? Now, all three of those contexts use the word resident, but they may define what it means to be a resident in different ways. And so a finding that one is a resident for purposes, say, of diversity jurisdiction does not necessarily mean that that person is also a resident for purposes of in-state tuition. Rather, what matters is the underlying legal context. And if that legal context is different, you cannot transport a word from one context to another. Let's say that in lawsuit number 1, a person was adjudicated to be a resident of New Hampshire for purposes of diversity jurisdiction. Under the doctrine of collateral estoppel, you cannot transport that meaning into a different legal proceeding where the question is whether a person is a resident for purposes of in-state tuition. Okay, let's go through the notes and problems which make this point in the context of the difference between criminal and civil proceedings. Note 1. The federal government criminally prosecutes an IRS agent, accusing her of stealing tax revenues. She is acquitted. The government then sues the agent in a civil suit to recover funds allegedly embezzled in the same criminal acts. The agent seeks to invoke preclusion on the grounds that the previous case demonstrates that the acts did not occur. Should the doctrine of preclusion apply here? Online student? Thomas?
I don't think so.
Why not? What is a key difference between civil and criminal trials? For example, what makes a civil suit for wrongful death easier to prove than a criminal prosecution for murder?
The burden of proof is much higher in criminal cases. So just because the prosecutor couldn't prove that she stole in a criminal trial doesn't mean that the government can't prove in a civil trial that she stole it, because all that is needed is a preponderance of the evidence, which is a lot lower standard.
Good. The key to understand the answer here is, as Thomas said, that the burden of proof is different in criminal cases than it is in civil cases. In criminal cases, the burden of proof is on the government to establish guilt beyond a reasonable doubt. In most civil contexts, however, the burden is to establish liability by a more likely than not preponderance of the evidence standard. So a determination that a person is not guilty in a criminal proceeding is merely a determination that the government did not prove the person's guilt beyond a reasonable doubt. It does not mean that the defendant is innocent of the crimes. Nor does it mean that the government cannot prove that it is more likely than not that the person engaged in the conduct that the government is charging. So no preclusion in that context. Note 2. Reverse the order of the civil and criminal sanctions in the preceding problem. Suppose the civil action came first and the government prevailed, winning a judgment against the agent on the ground that she had embezzled the funds. The government now prosecutes the agent criminally, charging her with the same acts of embezzlement. Why doesn't the first case preclude the agent from relitigating the question of embezzlement?
Is it because the government established the embezzlement at a lower standard, so there's nothing to stop them from trying at the criminal standard?
Yes. In the civil case, the government established that the agent embezzled the funds more likely than not. That by a preponderance of the evidence, the government established embezzlement, in other words. That does not suffice, though, to establish it beyond a reasonable doubt. So the meaning in the civil context cannot be transported to the criminal context. Note 3 says, suppose in problem 1, the agent had been convicted in the criminal prosecution. In the subsequent civil case, could the government take advantage of preclusion against the agent? What do you think? Online student?
I think so. Now that the government has a criminal conviction, they don't need to establish liability all over again in a civil trial because they've already met the burden. In fact, they exceeded it.
Exactly. In the federal system and most state courts, the answer would be yes, because the government has met a higher burden of proof with more procedural protections for the defendant. That, by the way, is why defendants sometimes plead nolo contendere, or no contest, rather than guilty to criminal charges. Doing so permits them to avoid preclusion in future civil suits. But the critical point here is that the issue must be the same in all relevant contexts. You must be aware of the legal context where the adjudication took place in case number one. If there are different standards that apply, or if there are different procedures that apply, or if there are different burdens of proof that apply, it is not going to be transferable unless we say for certain that the determination in case number one satisfies all the requirements of due process in case number two. Next, we'll talk more about what it means for an issue to be actually litigated and determined.